Hi and welcome. I see we're starting to have people join us. Thank you so much for being here today. We're going to take just a minute or so to make sure everybody gets signed on. And so I will take that time to do a little bit of housekeeping. I'm Lisa from the library, and today with me is Susana Aguilera from the San Diego Volunteer Lawyer Program, and she's going to be our speaker today. And a couple of things you need to know. This is going to be an interactive presentation where you are allowed to ask some questions if you have them. The way that you do that in the Zoom webinar, if you're not familiar with it, is the Q&A function. So you will see a Q&A icon on your screen with 2 speech bubbles. And if you click on that, you can type a question in. One of the nice things about that feature in Zoom is that you can do so anonymously if you'd rather, or you can do so using your name, whatever you're comfortable with. And Susana will try to get to as many of those questions at the end as possible. I should note, and she will also talk about this when she gets started, this is a presentation for general information purposes today and not individual legal advice. And so please keep the questions general. Susana will not be able to answer your individual questions about your specific case. However, she will talk to you about also how you can possibly get help from the San Diego Volunteer Lawyer Program and how to reach out to them. So that would be what we would recommend for individual advice. The other thing I wanted to mention before we get started is that you will see a link for a survey at the time you leave the presentation today. If some of you would take time to take our short survey, we always appreciate feedback, and you just can do that. It's just a little online survey with a link that you'll get on your screen. I think that's everything I had to say, so I'm going to turn things over now to Susana.
Okay, thank you. Hi, everyone, and welcome. Thank you for joining this webinar. My name is Susana Aguilera. I'm a staff attorney with the Tenants Rights Program at San Diego Volunteer Lawyer Program. At the Tenants Rights Program, we assist with a weekly clinic. We help tenants who have received notices to terminate their tenancy or move out. We also help with security deposit issues, rent increase issues, and reasonable accommodations. So in the future, if that's something that you need assistance with, please feel free to reach out to us. Like Lisa said, I'll have a slide at the very end where I indicate how you can apply for services to see if you qualify. And this PowerPoint will be sent out later in the day, so you'll have access to that information as well. Then, okay, so I'll get started. This presentation is about disability rights for tenants, and specifically it's about how a tenant can ask for a reasonable accommodation. First, a quick disclaimer. This presentation provides general legal information. It is not legal advice. I'm not going to cover every type of reasonable accommodation request. And if you do need legal advice about your specific situation, please talk to an attorney. And like I said, you may qualify for services through San Diego Volunteer Program. And if you do, we could potentially assist you. Okay, what is a reasonable accommodation request? So a reasonable accommodation request is a change in a housing provider's, a landlord, a property manager's rule, policy, practice, or service that may be necessary to allow a tenant with a disability the equal opportunity to use and enjoy their rental unit. For example, this one comes up a lot. Landlord has a no pets policy. It may be in the lease that the tenant signed, so no one in a rental complex is allowed to have any sort of pet. However, sometimes a person who has a disability may need an emotional support animal or a service animal. And in that situation, the tenant can ask for a reasonable accommodation request to have this emotional support animal or service animal. And I'll talk about more specifically those who can ask for a reasonable accommodation request. But in this specific scenario about the no pets policy, the landlord who does grant this reasonable accommodation request to allow the tenant to have an emotional support animal or a service animal cannot charge the tenant an additional like pet fee or security deposit. Okay. Okay, so there are different definitions of what a disability is at the federal level and at the state level. So at the federal level, a tenant must demonstrate one of these 3 things. It's not all of them, so it's just one of these. The first is they must show that they have a physical or mental disability that substantially limits one or more major life activities, or they have to have a record of that disability, or they have to be regarded as having such a disability. So it's just one of the three. In California, the definition is much broader, so it would encompass more people than at the federal level. So in California, a tenant just has to show that the disability limits major life activities. So at the federal level, it's substantially limits a major life activity, whereas in California, they just have to show that the disability limits major life activities. There's no substantial in it. And what's a major life activity? So I'll give you a list of things that can constitute a major life activity, but this list is not all encompassing. So it includes walking, seeing, hearing, eating, sleeping, standing, learning, performing multiple tasks, concentrating, etc. So if you can show that you have a disability that limits major life activity, then potentially you can ask for a reasonable accommodation request. Okay, some people don't qualify as having a disability, and those are individuals who actively use illegal drugs, those who pose a direct threat to the health and safety of others, or who would cause substantial physical damage to the property of others, those with sexual behavior disorders, compulsive gambling, kleptomania, which is the urge to steal, and pyromania, which is the urge to set fire to things. So if the person wants to make a reasonable accommodation request, but their disability is based on one of these that I mentioned, then they wouldn't qualify as having a disability. Okay. So when a person makes a reasonable accommodation request, a landlord must grant that request if it is needed to remove disability-related barriers to the full use and enjoyment of housing, and it doesn't create an undue financial or an undue administrative burden for the landlord. So later on in the presentation, I'll provide some examples of what an undue financial or administrative burden are. So if there's no undue financial burden, no undue administrative burden, and the request, the reasonable accommodation request is needed to remove disability-related barriers, and the landlord should grant the request. Okay, I'll provide some examples of common reasonable accommodation requests so that you get an idea of the type of request that you can ask for if you have a disability. So the first is change the date that rent is due based on when the tenant receives their disability benefit payment. So if a tenant receives a disability benefit payment, let's say it's the 7th of the month, but they signed a lease that says rent is due the 1st of the month, then the rent would be late every single month. So the tenant can ask for a reasonable accommodation request to change the date when rent is due for them from, let's say, instead of the 1st, let's say it's the 8th because they get paid on the 7th. And this would qualify as a reasonable accommodation request because the benefit that they get is directly related to their disability. Another example is for a closer or a designated parking spot. So let's say that the tenant lives in a rental complex that has designated parking spots for each unit. But a person who has, let's say, some issues with walking, with mobility, their parking spot is really far away from their unit, then they can ask for a designated parking spot that's closer to their unit. On the other hand, if a tenant lives in a complex that has a huge parking lot and it's just first come, first served, there's no spots are designated, the tenant can ask for a designated parking spot just for them that's close to their unit because they have mobility issues. Okay. Another example is to have an emotional support or service animal, like I mentioned previously. And I just want to highlight the difference between emotional support or service animals. So a service animal is one that's specially trained to provide a specific type of service to the person that they're assisting with. So for example, a guide dog, that's a service animal because they're specially trained to help someone who is blind or hard of seeing. Whereas an emotional support animal is not specially trained. They're there to provide comfort. So these animals, emotional support animals, are usually requested by people who have, let's say, depression or anxiety or something like that. So you can make a reasonable accommodation request to have some sort of assistance animal. Another one that we see quite a bit is notices to cure or quit. So a notice to cure or quit, these are typically 3-day notices to cure or quit, and they are given to tenants who are violating a term of their lease. And so the person, after being served this type of notice, only has 3 days to cure, so to correct the issue or quit, move out. And if the person does not correct the issue or move out within the 3 days, then the landlord can initiate eviction proceedings. So the consequences of not complying with this type of notice is really drastic. And the turnaround time is really fast. It's only 3 days. So people who do have a disability potentially don't have sufficient time to comply. So I'll provide an example. A tenant is renting a house. They have a front yard. The front yard is filled with objects such as like really heavy pots for plants, cardboard boxes filled with items, etc. The landlord serves a 3-day notice to cure or quit, asking the tenant to remove all the items from the front yard. But the tenant lives alone. The tenant has arthritis and issues with their back, so they can't lift heavy items. Based on this notice and based on their disabilities, the tenant can ask for more time to comply with the notice. And that way, instead of 3 days, they can potentially ask for a couple more days, weeks, depends on the situation. Last example, also one that comes up a lot is a tenant gets served a notice to terminate their tenancy. So a tenant can get this type of notice whenever they're on a month-to-month agreement. These notices range from 30 to 90 days, depending on how long the tenant has lived in the unit or if they receive some sort of subsidy. So if a tenant who receives this notice has a disability, which makes it difficult to pack all of their belongings, or maybe it's difficult to find a unit for them because they have certain issues that prevent them from walking up the stairs. They have to find a unit that's on the first floor, or they have to find a unit that's in a complex that has an elevator. It severely limits their ability to find a new home. Or, for example, they receive treatment at a facility that's near their home that they can walk to, that they don't have a car, so they have to walk there or take public transportation, then they can ask for more time to move out. And again, the amount of time that the tenant asks for is going to be dependent on their specific situation. Okay, so how does a tenant make this request? First, we highly encourage people to make the request in writing. It does not have to be in writing. It can be a verbal request, but it's always a really good idea to have everything in writing and proof of that writing. So that's why we encourage people to make the request in writing. You can give it to your landlord or property manager and keep a copy for yourself. And what should this request contain? So first, it should discuss the disability. It should explain the symptoms that the tenant has and how those symptoms prevent the tenant from obtaining equal housing benefits. The tenant does not need to state the name of the disability, but it's helpful to explain how it affects major life activities. Okay, so I'll provide an example. A tenant lives on a second floor unit of an apartment complex that has no elevator. The tenant can explain that they have limited mobility and back issues, and that climbing stairs exacerbates the pain they feel. And therefore, because of that, the tenant only leaves their house when it's absolutely necessary, because they know that if they leave, when they come back, they're going to have to climb the stairs and it's going to cause them a lot of pain. So again, no need to name specifically what the disability is or that they have a specific diagnosis, but just explain how this disability affects their ability to engage in major life activities. Okay. The request should also explain what it is that the tenant is asking for. What's the accommodation? So that could be a designated parking space, more time to move out at the end of the tenancy. To go back to the example I just provided, the tenant can ask to be moved into a first floor unit when one becomes available. That can be the request. And lastly, nexus. So this is really important. The letter should explain the connection between the disability and the accommodation. So there should be a clear connection between the disability and what it is that the tenant needs, what they are asking for. So again, in this scenario about the person living on the second floor unit, the tenant would indicate that having a first floor unit instead of a second floor unit would alleviate the pain that they experience when walking up the stairs, because they wouldn't have to walk upstairs anymore, and that it would help when they need to leave the home. They can leave the home more frequently and not when it's just absolutely necessary. Okay, verification. So a landlord can ask for verification of the disability, but only if the disability is not known, if the disability is not obvious, or if the need is not readily apparent. So the tenant I previously described, the tenant who lives on the second floor unit of a rental complex, if they have a cane or if they use a walker, then the landlord probably can't ask for verification because the need is potentially obvious in that scenario. But if otherwise the landlord can ask for a verification, then the verification letter can be written by a doctor, caseworker, social worker, or any reliable third party who's in a position to know about that person's disability and the need for the accommodation. And again, the person verifying, providing the verification letter does not need to name the disability. They don't have to state what the disability is. They just have to say that they know what the symptoms are, explain what the symptoms are, and how a change in certain policy can accommodate this person's disability. Okay. The interactive process. So if a landlord cannot provide the reasonable accommodation, then the landlord and the tenant engage in what's called the interactive process, which is just a discussion between the landlord and the tenant. In this situation, or in this process, in this discussion, the landlord can propose alternative accommodations, and if they cannot provide the accommodation that the tenant requested. And this discussion must be timely and conducted in good faith. And this is an opportunity for the landlord to seek more information if the letter or the request didn't provide sufficient information for the landlord to properly evaluate the request. So they can ask for more information about the nexus or the disability, the symptoms. And importantly, the landlord cannot deny the request without seeking clarification or additional information. And the California Civil Rights Department, which used to be called the Department of Fair Employment and Housing, has said that the housing provider must engage in this interactive process when a reasonable accommodation request is not granted. So again, to show that the request is needed, the person who is considering the request, so either the landlord or the property manager, they can't ask for information beyond what is necessary to evaluate the request. So they cannot ask for a specific diagnosis. They can't ask to see medical records, etc., things like that. Okay, so they should be, they shouldn't pry too much in when they are seeking clarification. And they can't ask for additional information if the tenant gave reliable info about the disability and why the request is needed, or they gave reliable information about the disability and the need, or if the need is known or obvious. Okay. Sometimes a landlord won't outright say that the request is denied, but so in some situations, a request will be considered denied, even if a landlord hasn't actually said it's denied. So I'll provide these examples. So a failure to reach an agreement can be considered a denial by the landlord. So for example, a tenant received a 30-day notice to move out. The tenant makes a reasonable accommodation request based on their disability. They need 60 additional days to move out. The landlord says, well, I can't give you 60 days for whatever reason, but I can give you an additional 2 weeks. And the tenant says, no, I need at least 45 days. And then the landlord never says anything in response to that. So they didn't reach an agreement. So in that situation, that request can be considered denied. A failure to engage in the interactive process can be considered a denial. So if, let's say, the tenant made a reasonable accommodation request, but there was insufficient information in it for the landlord to properly evaluate the request, and the landlord didn't engage in the interactive process, then that would be considered a denial. And if a landlord fails to respond to the reasonable accommodation request within a reasonable amount of time, that also may constitute a denial. And again, for what's considered a reasonable amount of time will depend on the situation. So if a tenant receives a 3-day notice to cure or quit, and the tenant asks for, let's say, 2 more weeks to comply with the notice, those 2 weeks, the landlord doesn't respond 3 days, within the 3 days that the notice is set to expire, that may constitute a denial. Not sure, but because these things move so fast, it potentially, like, waiting more than 3 days could potentially be considered a denial because the notice expires in 3 days. So if your request is considered denied, then you can file a complaint with either the California Civil Rights Department, formerly the Department of Fair Employment and Housing, or with the Department of Housing and Urban Development, which is the federal agency. And these complaints must be filed within 1 year from when the harm occurs. It's a very short time frame. You can also bring a private lawsuit against the landlord, and I believe the time frame for that is within 2 years. Okay. So The landlord can deny a reasonable accommodation request in some circumstances. So these are some examples. So if the request is not made by a person with a disability or on behalf of a person with a disability, then the request can be denied, because reasonable accommodation requests are only an option for people who can show that they have a disability based on the definitions I provided at the beginning of the presentation. If they can also deny it if there's no disability related need for the accommodation. So if the person just wants a closer parking spot to their unit, but they don't have a disability, or if their disability is unrelated to why they want the spot closer to their unit, then the landlord can deny it. Or lastly, which I talked about at the beginning, is the landlord can deny a reasonable accommodation request if it would impose an undue financial burden or an undue administrative burden, or if the request would fundamentally alter the nature of the landlord's program. So I'll provide some examples of what that means. Oh, also, I forgot to mention that a reasonable accommodation request cannot be denied just because it would be perceived as unfair to others. So if the person who asks for a designated parking spot because of a disability they have a mobility issue, and none of the parking spots are designated, but the tenant needs a designated parking spot, the landlord can't just deny that request because they would only be granting a designated parking spot to one tenant. That's not a reason to deny the request. Okay, so what are some examples of an undue financial or administrative burden? So the first example here I have we'll showcase that. So a tenant is physically unable to open the dumpster in the parking lot. The tenant requests the landlord send a staff person to his apartment daily to collect his trash and take it to the dumpster. However, this housing development is small. Let's say it has only 4 units. They have limited financial resources, and maintenance staff is only on site twice per week. This could constitute both a financial burden and an administrative burden for the landlord. Financial, because they would have to hire someone to go to the complex every single day, whereas now their staff is only required to go twice per week. It could also be an administrative burden because they'd have to make sure that the person does go there every day to make sure that this reasonable accommodation request is met. The second example showcases a fundamental alteration in the nature of the provider's operations. So tenant has severe mobility impairment that substantially limits his ability to walk. He asks his landlord to transport him to the grocery store and assist with grocery shopping. However, this landlord does not provide any sort of transportation or shopping services for its tenants. So this would be considered a fundamental alteration in the nature of the provider's operations. So in these two scenarios, the landlord can deny the request because they would be an undue financial and administrative burden, the first one, and the second one, it would fundamentally alter the nature of the provider's operation if the landlord was to grant that request. Okay, so now I'm going to provide an example of a reasonable accommodation request and go through basically all the steps that I mentioned previously. So Liz has Alzheimer's, which affects her ability to manage her finances. She writes a letter to the property manager explaining that her daughter will be paying her rent and makes a reasonable accommodation request that all notices relating to her rent be sent to her daughter instead of her. The manager tells Liz that they have a policy of only sending notices to residents, no exceptions. So the request that Liz is making is a reasonable accommodation request for a change in this policy of who gets notices. Several months later, Liz receives an eviction notice because her daughter had not known that Liz's rent had been increased. So she paid the previous amount, not the new increased amount. So based on that, Liz can file a complaint with the California Civil Rights Department because denying a reasonable accommodation request is a form of disability discrimination. In this scenario, providing notice to Liz's daughter of a rent increase or any changes in rent would not pose an undue financial or administrative burden. They would just have to change, the address on where they send the letters, the notice. It wouldn't be a fundamental alteration of the landlords program. So they should have granted this request. And Liz showed that there's a disability. She has Alzheimer's. And she's explaining what accommodation she needs. And she's providing the nexus, right? She has Alzheimer's, she forgets, and it limits her ability to manage her finances. So these notices need to be sent to her daughter. Okay, so in this situation, she would have, the landlord should have granted this request. They can't just say no exceptions. Okay, unlawful detainer. So an unlawful detainer is an eviction lawsuit brought by a landlord against a tenant. So an individual with a disability may raise failure to provide a reasonable accommodation as an affirmative defense to an unlawful detainer. So if, for example, like I mentioned, a tenant receives a notice to terminate their tenancy, to move out, and the tenant has a disability, they can't move out within the 30-day time frame they have, and they made a reasonable accommodation request. The landlord denied it. The tenant, because they have this disability, they haven't been able to move, and so the deadline on that notice to terminate has come and gone. The landlord would file an eviction lawsuit, but the tenant can raise a failure to grant this reasonable accommodation request as an affirmative defense to this eviction lawsuit. And really important is that tenant can make a reasonable accommodation request at any time, including after this unlawful detainer lawsuit has been filed. Okay, so here I provide some sample language that a tenant can use in a letter to their landlord, property manager. Again, we highly encourage people to put the request in writing. And this is very short, but I just wanted to make it as simple as possible so it would be easy to read on a PowerPoint. But it just says, dear property manager, as a reasonable accommodation request for my disabilities, I ask that you provide me with a designated parking spot that's close to my unit. I'm an individual with disabilities for the purposes of federal and state fair housing laws, and I'm therefore entitled to reasonable accommodations in housing. And then the citation is to both the federal law and the California law. And then I explain briefly what the disability, the symptoms. I have chronic physical disabilities that limit major life activities for which I currently receive ongoing treatment. I experience pain when I walk and I use a cane. Having a designated parking spot close to my unit will help alleviate the pain I feel in my legs when walking to and from my car and my unit. And then lastly, just confirm in writing by a certain date whether the reasonable accommodation request has been granted. Okay, and this is how you can contact us if you do need to make a request for reasonable accommodations. You can either call us by phone or you can apply online. You do have to qualify for services, but we can help you with that to see if you qualify. So now I'll take questions if you have any. I know someone had a question on whether this applies to homeowners associations. And yes, laws on reasonable accommodations do apply to homeowners associations. Okay.
So we have a couple of others. Did you want me to read those or do you want to read them?
I can read them. Let's see. Does a resident need to provide the doctor's name, phone number, letter of proof of disability? I'm not sure. So I think so long as it's it has like the proper letterhead, I think that's fine. Proof of disability, no. They just have to explain what the symptoms are, how it limits major life activities, that the need is that this is what the person needs. But no, they don't have to provide like medical records or anything like that. Okay. If residents are not allowed to park in guest parking areas, can a disabled resident request reserved parking in the guest parking lot? Presumably they can if that a parking spot that's in the guest parking lot is the closest one to the tenant's unit. Any other questions?
Got plenty of time, everyone. So if you have any, please feel free to jump on the Q&A here and type in your question. We'll give you another minute. Here we go. Somebody else has one here.
Can a tenant request early termination of the lease as a reasonable accommodation? Is there a particular process timeline for that? Can a tenant? Yeah, I think so. I haven't dealt with this issue, but I don't see what the problem would be with requesting early termination of a lease. Typically, there's a fee associated with early termination of a lease, but if the need is if it's it's a need that the person needs to move out of the place because living there exacerbates their disability, I don't see what the issue would be with that. And you can potentially request the tenant doesn't have to pay the fee that's associated with it. Is there a particular process timeline for that? No, like I said, you would make the request in writing. You would explain what the issues are, what you're requesting to early termination of the lease. And you can set a deadline as well. So like in the sample letter that I had, I based it off of today's date, the 10th. So I asked for a response within 10 days. But if this is a really serious issue for the tenant, they can ask, that they respond by a certain time, but there's no specific timeline. They just have to respond within a reasonable time. And it really depends on that situation.
While we're waiting to see if anyone else has any questions, I just wanted to mention that we will be emailing the slides to everyone who was registered today. So don't worry about taking pictures or taking notes. For this contact information here, the sample letter, I will be sending that all out by email when we're done today. So just wanted to make sure that was clear. So we can go ahead and wrap up if we don't see any others popping up shortly.
Okay.
Really appreciate everybody being here today. I think this is a really useful, practical presentation. We appreciate so much from San Diego Volunteer Lawyer Program. Well, while I have everyone's attention here, I want to mention that we do have another presentation coming up next week with the Volunteer Lawyer Program, I believe on the 17th. 17th? I don't have it in front of me right now, sorry. Check our classes page on the San Diego Law Library website and you will find it there. But we will also be taking on another tenants' rights issue related to security deposits and the law involving security deposits. So just wanted to make sure everybody who was here today knows there is another presentation coming up next week that you might be interested in. So got a couple more questions, Susana.
Does a reserved parking space need to be for a daily use vehicle? I mean, I would think so. If the person borrows a car, I don't know, once a week, but they borrow it once a week every week, then no, like they can still make the request if it's a car that they're using on a consistent basis, even if they don't have it. It's not a daily use car. But I would imagine if they don't have a car at all and they're just borrowing one, then, and sorry, they don't have a car at all and they're just renting one once a year, then maybe that's a different situation. Can they use reserved parking spaces for storage? No. How does a tenant engage a SDVLP for their particular matter? So yeah, we have a website. We help with various issues, not just tenant landlord issues, family law issues, restraining orders, custody, education law matters. So you can go on our website and our phone number is on there, our general phone number. You can also just apply online for many of these. There's specific links for specific programs. So if you have a family law matter, you would go online, you'd click on the particular link and you provide some basic information, and someone from our office will contact you to ask more questions to see if you qualify. So the issue you have has to be something that SDVLP assists with, and you also have to meet a couple other criteria to qualify for services. So definitely, if you have an issue that you think we can help with, go to our website and check it out, and you can apply for services and someone will contact you.
No, I don't see any more questions, so I think that'll be it for today. Again, thank you so much, Susana, for all this information. We will be emailing out the slides to everybody, and just thanks to everybody for coming today. As I mentioned at the beginning, you will see a link to a survey as you leave today, and we'd appreciate if some of you would take time to take the survey for us. And you're welcome to the person that just typed thank you. Thank you, everybody.
Thank you.